Okay, so welcome everybody. Hoping audio and video is good to go. Um, you might be wondering what this is. It's a picture of. I've been trying to use a virtual whiteboard because teaching 222 this semester, and I was trying to do some lectures using this, and I just had my back to the camera the whole time. So I'm trying to do a more technical route, so I figured I'm going to keep that whiteboard up there just in case this technology doesn't agree with me, so to speak. But I replaced it, or covered it up now, with a picture of the Trinity test. So those of you who don't know what the Trinity test was, this is the first test of an atomic weapon in the world that we know of, at least. Took place on July 16th, 1945, in the desert of New Mexico. And it was basically the beginning of the end, right? Or the beginning of the atomic age, at least. One thing that's interesting, I think, and one of the reasons why, I love this image so much. There are a few, but Oppenheimer was a physicist, a nuclear physicist who worked on the Trinity project. There were thousands of people who worked on developing the first atomic bomb, but he's often credited as kind of like the granddaddy of nuclear weapons. And he witnessed this test in person from very, very far distance. And he said that when he saw this test, it gave him an unbelievable sense of dread. And he said that he could only be reminded of a quote that appears in the Bhagavad Gita, which is a religious text in Hinduism. A quote that says, "Now I am become death, the destroyer of worlds." So basically changed him and made him reevaluate his life's work, and basically what he helped unleash onto humanity. But it's so beautiful, right? So to see such a beautiful image of something so horrifically destructive, I like the irony in it. And it's also quite amazing what humans can do for good, and clearly for bad as well. But that being said, and out of the way, we'll get going with this week's lecture that's going to deal with the topics of insanity and competency. So both of these are issues that will from time to time come up in the legal system. We usually think, insanity, competency for trial, but we'll also see that competency in particular comes up through various parts of the legal process. Both of these concepts are psychological in nature, but the term insanity is not a psychological term. It's a legal term. So, it's not polite or politically correct anymore to call people crazy or to call a situation crazy, because there's been, thankfully, a lot more awareness and a lot more sensitivity to issues of mental health. So the word crazy is kind of, some people are, choose something else. I would say insane is still a good or acceptable word for now anyway, but I'm old, so what do I know? Why is it okay? Well, because it's a legal term, right? It's not a psychological term. You're not going to find this word in any DSM criteria. It's not a diagnosis or anything. So we could still say, that person's insane, or if the situation was insane, then we're talking legalese. But well, that might not last for long either. Either way, if we're dealing with competency or insanity, we're talking about some type of assessment that needs to happen, right? So people will have to be assessed for insanity if they're trying to plead not guilty by reason of insanity, or defendants would need to be assessed for competency, typically to competency to stand trial, but we'll see. There's also there's plenty of times, or various times throughout the criminal justice system or process, where the issue of competency can come up. Either way, there would be some type of assessment done, and these assessments are typically performed by clinical psychologists, or people with counseling degrees, masters in social work, say, for example, who are specifically trained to do these types of forensic assessments. So we know that forensic psychology is recognized as a specialty by the American Board of Professional Psychology, and also by the APA. Finally, only about 20 years ago was that the case. And when it comes to who is qualified to do these types of assessments, a qualified expert is going to be somebody basically who the judge deems to be qualified. But the judge would hopefully be taking a look at this person's credentials, whether or not they're licensed, how long they've been practicing, what kind of assessments they do, what are they trained in, what's their area of expertise, specialty. Take a look at how long they've been doing it, how many cases have they worked on, so on and so forth. But ultimately, when it comes to the courtroom, the judge has a ton of discretion. So keep that in mind, because I'll be the judge for our mock trials, so you're going to want to stay on my good side here. But once somebody is deemed qualified, a qualified expert can testify about a topic if this testimony is relevant to an issue that's in dispute, and if the usefulness of this testimony outweighs whatever prejudicial impact it might have. So you can imagine, for most people who would serve on a jury, being presented with testimony from somebody who has doctor in front of their name, or who has the initials PhD up their name, you can understand how they might give more weight or credibility to that person's testimony. So there is some potential for prejudicing the jury. At the same time, people with those titles and those degrees often times have specialized knowledge that they can share with the jury to inform them as the triers of fact. They have to reach a verdict. So this information can be useful, and judges will typically rule or make a decision whether the usefulness of the testimony outweighs any potential for or any potential prejudice that testimony might give or create. So when it comes to this issue of competence, so sometimes people will will use insanity and competency interchangeably, or get them mixed up. And, kind of makes sense, because how often do we really encounter those terms in our daily lives outside of academia or these legal shows that we watch on TV? But when we talk about competency, we're referring to a defendant's capacity to function meaningfully and knowingly in a legal proceeding. Okay, that sounds a little vague, and it is a little vague, but luckily the courts, and actually the government, the federal government, has also provided guidelines as to what exactly this means and how exactly we should, or what kind of things we should look for when determining whether somebody is competent or not. So defendants may be determined by a judge to be incompetent if they are seriously deficient in one or more abilities, such as understanding the legal proceedings, communicating with their attorneys, appreciating their role in the proceedings, making legally relevant decisions. So we're basically taking a look in terms of competency of whether or not a defendant can meaningfully participate in their own defense, essentially. We all have the right to defend ourselves, and if you're not in the right state of mind to be able to do that, then we typically have to wait until you are in that right state of mind, or we'll see in a moment, take some type of intervention to get you in the right state of mind. But when we are judging competency, we're trying to determine whether or not a defendant really understands what's going on, and if they're able to meaningfully and impactfully participate in their own defense, which is going to include understanding legal proceedings and being able to communicate with their attorneys to come up with legal or to come up with some legal strategy or a defense strategy, and to help make legally relevant types of decisions. When it comes to what the nationally accepted standard for competency, this comes out of a Supreme Court case. Remember, I said we'll be talking about Supreme Court cases all throughout this semester because we operate under a common law system, which basically means that court decisions, court rulings, particularly from the Supreme Court, that's it. That's where it all ends. That's the last one. And we have a vacancy at the moment here, so been a rough couple days. Been a rough couple years, particularly rough the last couple of months. But anyway, the Supreme Court ruling that kind of set the standard for competency was Dusky v. United States, and this was in 1960. And the court ruled that in order for ruled that the national standard for competency to stand trial is a, quote, sufficient present ability to consult with one's attorney with a reasonable degree of rational understanding and a rational as well as functional understanding of the proceedings against one, end quote. So again, going back to this idea, do you understand what's going on? Do you understand why you're in the courtroom? Do you understand what you're being charged with? Do you understand what the potential penalties are going to be if you're found guilty? Are you able to help in defending yourself, including communicating with your attorneys? These are things that a judge would be looking for in terms of determining whether or not somebody is competent to stand trial. So this has since been dubbed the Dusky Standard. And the Dusky Standard does not specify exactly how the evaluator assessing competence, typically the judge, right? It doesn't really determine or specify how the judge should judge the sufficiency of rational understanding, or the ability to consult, or this notion of factual understanding. It's really left to the judge's discretion. So once again, we definitely want competent judges. In the literal sense, no pun intended, since we're talking about competency here. We want judges who are able to be fair, and who are also able to recognize deficiencies in cognitive functioning when they're present, when they're observable. That's not always easy to do. Again, it shows how psychology can play a very important role in terms of legal proceedings, and in this case, trials, right? Hopefully a judge will have some type of experience in recognizing when a defendant is lacking in these areas. So we have the Dusky ruling. Again, there are some things that a evaluator, again typically a judge, may consider, such things as understanding. So in terms of whether or not the defendant knows that the roles of each of the key participants in the process. So do they know what their attorneys are supposed to do? Do they know what the prosecutor is trying to do? Or do they know what the judge's purpose is? Do they know why those 12 people are sitting against the wall just listening? Do they understand each of the different people in this situation and what they're there for? When it comes to understanding, do they understand the charges that they're facing? Do they know what these charges mean? Can they comprehend what they're actually being charged with? Do they understand that? Again, do they understand the consequences of being convicted of those charges? What is it going to mean if you are found guilty? If they are going to make a guilty plea, do they understand that they are waiving their rights, and do they understand what rights exactly they're waiving? So a judge, I'll try to find examples of this to show before, like as part of our mock trial prep, to listen to a judge when somebody makes a guilty plea. The judge will ask a number of questions. Number one, making sure that it's a voluntary plea of guilty, that it wasn't coerced, and that the defendant making a guilty plea understands exactly what it is that they are subjecting themselves to in terms of punishment, and that they understand that they do have rights to a trial, that they don't have to plead guilty. Another area or ability that a evaluator can consider is the notion of appreciation. So does the defendant appreciate the likelihood that they will be found guilty? So let's hold on to, or let's examine that one a little bit. So the vast majority of cases, criminal cases, are never going to make it to trial. Vast majority, 95, 98%, somewhere in that range, are pled out, meaning that the prosecutor and the defendant, or most likely the defendant's attorney, and the prosecutor will, or district attorney will, come up with a deal so that you will essentially plead guilty to a lesser crime and receive a lesser punishment. Prosecutors do this in order to avoid going to trial, because there is no way that we would ever be able to handle, the system just can't handle jury trials for everyone. There's not enough time, there's not enough space, there's not enough judges, prosecutors or lawyers to make that happen. So a typical scenario is if somebody is found guilty, or let's just take a college student as an example. Maybe might have had too much to drink, and they had to relieve themselves. They had to pee, basically, and everything's closed. So they pee against a wall on Main Street, against a building, and a cop sees them do that. It would not be unusual. I mean, this is kind of a silly example, but things like this have happened, but it would not be unusual to be charged with maybe 5 or 6 different offenses. So maybe public urination could be one of them, but indecent exposure could be another one. Disturbing the peace could be another one. If you were unlucky enough to do that within a certain distance from a school or a daycare center, now you're facing sex crime charges, and the likelihood that you will have to register as a sex offender for the rest of your life. So you get arrested, you get in public intoxication, God knows how many different charges, but they're gonna do what's called quote-unquote overcharge. So they're basically gonna hit you with every possible thing imaginable, anything they could possibly potentially charge you with. They will say that, hey, look, this is what you're facing, right? And if you get convicted of all of this, like, you're spending this many years in jail. So instead of going to trial and fighting this, why don't you just plead guilty to the public intoxication or the disorderly conduct, and we'll drop all the other charges. So you'll just do some probation or pay a fine or something. So what are you going to do? Are you going to take that plea, or are you going to go through trial and risk being a sex offender, or risk felony charges, spending real time in prison? So, the notion of overcharging, throwing everything at a person is there to kind of pressure them into taking a plea. Now, prosecutors, like everybody, stake their reputation and their success in terms of winning cases, right? How they succeed. So for them, losing a case is not good. So typically speaking, if a prosecutor is willing to go to trial, the prosecutor is certainly convinced that they have a pretty good shot that you're going to be found guilty. They're pretty confident about that. Otherwise, they would not take the case to trial. That's just as a side note. So keep that in mind. Just, God forbid you ever need that bit of information. So when we're dealing or trying to determine whether somebody is competent, do they appreciate that, hey, you're likely to be found guilty. There's a whole bunch of evidence against you, right? Does the person appreciate that? Again, do they appreciate the consequences of being convicted? Not just do they know, like, yeah, you'll go to jail, but can you really appreciate what that means? Do you really know, not just that you're going to go to jail, but do you know what that entails? what life is going to be like for you. Um, Also, can they appreciate whether or not it's in their best interest to testify? Remember, we have a Fifth Amendment right to protect ourselves against self-incrimination, so we do not have to testify. And again, it's up to the state to prove that we did something wrong. We don't have to answer anything. We're not compelled to offer evidence against ourselves, but sometimes people do want to take the stand to tell their story. It's usually not a good idea, even if you're not guilty. It's usually not a good idea. But if somebody chooses to take the stand, do they appreciate, that they're going to be faced with cross-examination that might actually not be a good idea to take the stand to testify in their defense. Another area that we can assess is reasoning. So, is the defendant able to distinguish between more relevant information from less relevant information? Or are they kind of treating everything equally? Are they kind of putting as much weight and arguing over something really mundane, while ignoring, a really important factor that's involved in their case? That's something that we would want to consider in determining whether or not the person is capable of reasoning. Are they able to weigh and evaluate various legal options that are available to them? So not just legal options in terms of whether you want to take a plea deal or whether you want to go ahead with a jury trial, or if you want to waive a jury trial and have a bench trial. Bench trial is where you say, it's okay, I don't need a jury trial, I'll let the judge basically rule whether I'm guilty or not guilty. Is the defendant able to weigh and evaluate those different types of options that are available to him or her? Also, are they able to provide reality-based justification for making particular decisions? It is a legal option for you to represent yourself at trial. That's usually a really bad idea. And there's a famous quote that I'll totally mess up, but it's along the lines of a defendant who represents himself as a fool for an attorney, essentially, right? It's like you definitely don't want to represent yourself in a criminal case, right? So let's say that you decide, yeah, actually I do. A judge is gonna ask you to justify that, and if you can't give a good justification, it might call into question your competency, because you're not really able to provide justification for these types of decisions. Or if, like, in the middle of a trial you want to fire your lawyers, you want new ones, a judge is gonna try to figure out, well, why, you better be able to provide a reasonable, convincing answer that's not totally off the wall in that regard. Also, as we have been mentioning, whether somebody can assist in their own defense. So that involves whether the defendant can consult with their lawyer, if they can help plan legal strategy, if they can help challenge witnesses, so they're not going to be doing the cross-examination, but if they could come up with some questions or topics during the planning stage for what their lawyers might want to ask or delve into. Whether a defendant can testify relevantly. meaning that if they do wish to take the stand, are they actually able to get up there and make sense and testify to the facts of the case involved in the case? Also, are they able to just manage their courtroom behavior, or are they going to cause a disturbance? These are all things that you can imagine a defendant who is causing a disturbance, who's not able to manage their courtroom behavior. You can imagine that that's going to influence the jury's judgment. We would imagine so, right? Jurors are humans, so it could definitely be prejudicial in that sense. Okay, so those are issues in terms of when a defendant is going to trial, but the issue of competency also comes up when a defendant pleads guilty. And we touched a little bit about this, on this a little bit when I was kind of jumping ahead a bit. But by pleading guilty, we know that we're waiving several of our constitutional rights. That includes the right to a jury trial, the right for us to, or a defendant to, confront their accusers, the right to call witnesses in their favor, and also their right to remain silent. By pleading guilty, you're certainly incriminating yourself, right? That's pretty much the ultimate form of self-incrimination, by saying, yeah, I did it. So we're waiving a bunch of constitutional rights. So by pleading guilty, judges are going to make sure that people understand this and can fully appreciate what waiving those rights actually means, right? The Supreme Court has held that waiving these important rights must be done knowingly, intelligently, and voluntarily. So again, it'll be up to a judge to determine whether those three criteria are being met when a defendant is pleading guilty. Okay, when does the issue come up? How do we raise the issue of competence? The question of a defendant's competence can be raised at any point throughout the criminal process, even during arraignment, just when formal charges are being presented by the court. So it could be raised at any time, and it can be raised by anyone, basically, any side. The prosecution can raise the issue of competency, the defense can raise it, or the judge can raise the issue, him or herself, right? Once the question of competency is raised, the judge will typically order an evaluation of the defendant. And that evaluation is usually done by somebody who does these things for the court. If there's some type of dispute, the judge will try to find somebody to do the evaluation who would be equally acceptable by both the prosecution and the defense. So once the issue is raised, there will be an evaluation. The issue of competency also arises when a defendant pleads guilty, as we saw. There will be a number of questions that are asked, and if the judge is not comfortable with the answers that they are receiving, they might order a full evaluation before they would accept a guilty plea. So how do we actually evaluate competency? How do we determine whether or not someone's competent? Well, most of these evaluations are conducted on an outpatient basis, so the defendant doesn't have to be hospitalized or anything like that. The person doing the evaluation will either visit the defendant while they're in jail waiting for trial, or the defendant will be brought to the evaluator on an outpatient basis. Physicians, psychiatrists, psychologists, and social workers are authorized by most states to conduct competency examinations. So again, you don't necessarily need a medical degree or a PhD to do this. There are plenty of social workers who are authorized to do these types of evaluations. Having a mental illness or a disability, this is a common misconception, that just because somebody is mentally ill or mentally disabled or developmentally disabled, this does not guarantee that a defendant would be found incompetent to stand trial. So competency is not determining whether somebody has a mental or developmental deficiency or disability. It really all comes down to whether or not they can understand the trial proceedings and participate in their defense. So, people who have certain mental illnesses and certain disabilities, sure, will certainly call into question someone's ability to participate in their own defense and understand what's going on. But the vast majority of mental illnesses and various disabilities, not necessarily, right? So there are a number of different instruments that are used to assess competency to stand trial. And these instruments are often used as part of a overall evaluation process that also involves interviewing and long interviews and evaluations of defendants. But let's take a look at some of these instruments here. You don't need to memorize these or anything. I present them here to kind of give you an idea of the different types of instruments that exist. Kind of get a feel for how the evaluation process proceeds. So the first instrument that we'll talk about here is called the interdisciplinary fitness interview. And there's a revised version of this, or a revision version of this. And these are semi-structured interviews that evaluate a defendant's abilities in 5 specific legal areas and assesses 11 categories of psychopathological symptoms. So with this type of, interdisciplinary fitness interview, it's a structured interview, which means that there are very specific interview questions that are asked. And in this case, we see that these questions revolve around 5 legal areas and 11 categories of psychopathological symptoms. We also have the MacArthur structured assessment of the competence of criminal defendants. That's a long title. And that acronym isn't much shorter there. This actually consists of a vignette about which the defendant is asked 82 questions that tap into these foundational and decisional abilities. So in this type of assessment tool, the defendant is presented with a vignette or a short story, and they're asked a whole bunch of questions about that story. And some of those questions are going to tap into whether this person can remember basic information, and also try to understand whether or not this person is able to make decisions about this vignette, make rational, sensical types of decisions about this vignette. we have the interview or the fitness interview test revised, the FIT-R. This includes 16 items in 3 broad domains. So factual knowledge of criminal procedure. So again, getting to this idea of whether or not the person understands the proceedings that are happening against them. Appreciation of personal involvement in and importance of the proceedings. So do they know what's going on? Do they know the importance of what's going on? And do they understand their role in what's going on? And of course, as we've been saying, the defendant's ability to participate in their own defense. The evaluation of competence to stand trial, revised version, is a semi-structured interview. So this semi-structured interviews are interview questions that typically a semi-structured interview would have yes or no question, or like a rating question, but also give the opportunity to elaborate. So you kind of get a close-ended question combined with an open-ended question, or the potential for an open-ended response there. And this particular instrument was developed using the Dusky criteria. So it focuses on information that is specific to the case at hand, and it addresses whether the person being evaluated is trying to exaggerate or fake deficits. So that is a concern that many people have. How do you know if somebody's faking it? If they're faking some type of mental illness to try to avoid trial. And geez, the name is totally escaping me. And it wasn't that long ago. But there was an alleged mafia godfather, my mafia boss. I say alleged because I don't want to get whacked in case some of you know somebody. It's all alleged. But he was awaiting trial, and he was, while the government was building a case on him. He was formally charged, but waiting for trial. He started like walking around the neighborhood wearing like a pink bathrobe, or going out in his boxer shorts and knocking on neighbors' doors, and acting oddly. And people were convinced that he was bullshitting. He was trying to be found not competent to stand trial. He was basically trying to get out of standing trial. So it does happen, right? But there are ways to detect whether or not somebody faking it. Typically, it's done by asking the same question in various different ways, and also evaluating how people answer questions. We already saw in terms of detecting deception that there are things that we can look for in terms of determining if someone's faking it. So people who fake these interviews usually try too hard. They give the most extreme wrong answers that somebody who has a legitimate deficiency would not give. That type of answer. They kind of go a little too much. It's a little too on the nose, right? It's like, really? That's kind of very stereotypical. You're acting like a stereotype of someone who's incompetent, not how somebody who is really incompetent would act. But when it comes to how common this is, how common is faking an illness in terms of competency evaluations. The estimates put it at about 18%. So that's not insignificant. I mean, it still means that the vast majority, 82% of the time, we're not dealing with someone who's trying to fake not being competent, but 18% still enough to keep your eyes open, right? So very poor performance would definitely be suspicious. People are giving really way out there responses to questions that would make somebody pretty suspicious. So an evaluator is suspicious. The Miller Forensic Assessment of Symptoms test. So this is a 25-item structured interview that can identify individuals who are attempting to fake mental disorders. Again, most people are not trained psychologists. They don't understand. Even if they look up some symptoms on Google, WebMD or Wikipedia or something like that, they're not going to be able to fully appreciate or understand the nuance that comes with these type of symptoms. They'll, again, typically will act in very stereotypical ways. Again, most people are not psychologists, so it's going to be more difficult for your average person to be able to convincingly fake or get one over on a trained professional. So evaluators usually give a report to the judge after they're done with their assessments, and this report will summarize the evidence on competence to stand trial, but sometimes there'll be an actual hearing where the people who, sometimes it's more than one evaluations that are taking place, if particularly if the first evaluation is kind of inconclusive, or the judge determines I don't know, maybe I want a second opinion on this. But typically the judge will get a report of the evaluation, and he or she will make a decision of competency based on that. Like I said, sometimes there's a hearing and the evaluators will be brought in, and both sides will have an opportunity to ask questions of the person who did the evaluation, or persons who did the evaluation. So in a competence hearing, a state can require that a criminal defendant prove that he or she is incompetent. So we'll see this notion of what's known as an affirmative defense. An affirmative defense, so the way that criminal trials work is you are guilty until proven innocent, except when we have issues of affirmative defense. So an affirmative defense, an example would be self-defense, right? Murder, self-defense. So you say, yeah, I killed the person, but I did that in self-defense. Okay, that's an affirmative defense because you basically pled guilty to killing this person. Now it's up to you to convince us that it was self-defense. Another affirmative defense is not guilty by reason of insanity. You basically have to prove beyond a reasonable doubt. Well, not always. Sometimes it's a preponderance of the evidence. We'll talk about the difference in a second. But you have to prove that, yeah, no, you killed this person, but you weren't in your right mind when you did it, depending on what standard we're using for insanity. So affirmative defenses mean that it's now up to the defendant to prove that they did something because of some reason. So when it comes to competency hearings, you're considered competent unless you can prove otherwise, or unless it is proven otherwise by an evaluator. So most states establish this criterion for competency to be a preponderance of the evidence. So what's a preponderance of the evidence? Well, basically there's two legal standards in terms of reaching a verdict or reaching a decision. One is beyond a reasonable doubt, and beyond a reasonable doubt does not mean beyond all doubt. It means beyond a reasonable doubt. So it's actually very close to the alpha level that we use in psychological research. So we don't have to be 100% sure when we reject a null hypothesis. We just have to be at least 95% sure, right? Because we have an alpha of 0.05. Alpha means that's, remember, the maximum risk we're willing to take in being wrong. The maximum risk we're willing to take in making a type 1 error, which means that we reject a null hypothesis when we should not have rejected the null hypothesis. We can take up to a 5% risk. Alpha is 0.05. So as long as our actual risk, which in statistics is our p-value, so long as our actual risk is less than our alpha, so long as p is less than 0.05, we say the result is statistically significant. A lot of researchers say that the beyond a reasonable doubt criteria is pretty much the same as what statistical significance is. At least 95% confidence. That means some innocent people are gonna be convicted. Just like in science, some false or true null hypotheses are going to be rejected, because the standard is beyond a reasonable doubt, not all doubt. And in science, we could reject a null hypothesis when alpha is less than, or p is less than 0.05. P doesn't have to equal 0. We don't have to have 0 risk of being wrong. We just have to have less than a 5% risk of being wrong. So in terms of what happens to these defendants, about 70% of the defendants who are referred for evaluation are ultimately found competent to stand trial. So even those defendants where the judge might have some questions about and orders an evaluation, 70% of those cases the defendant comes back saying they come back competent, or the judgment is that they are competent. You can proceed with trial. That number actually goes up to about 90% if it's a very vigorous type of evaluation that's done, and if there's a hearing involved as well. So the vast majority of people who go for evaluations in terms of competency are ruled competent, and you proceed with the trial. Sometimes if a defendant is deemed not competent to stand trial, again, it would all depend on what kind of crime that we're dealing with, and if it is kind of obvious that this person is not really fit to go through a trial at the moment, sometimes the district attorney will drop the charges if the person agrees to receive treatment. Again, that would be for some the misdemeanors or some of your class C or D felonies, but not murder 1, or none of those big felonies. That would be unlikely for a prosecutor to do that. Instead, they're going to try to restore competence and try this person. So how do you restore competency? Because we just said, well, this person was found that they can't participate. They don't know what's going on. They can't participate in their own defense. How you restore competency? Well, we get them to a point where they do know what's going on and where they can participate in their own defense. And then we put them on trial. So how exactly does this work? And how successful is this process, right? Can it be done? Well, yes. Yes, it does. Definitely can be done. So how successful are the efforts? Well, most people who are found not competent will actually have their competency restored. And this usually happens with about 6 months worth of treatment. So about 6 months of being on medication and or in therapy, talk therapy. Most people are going to have their competency restored. And we see here that the most important intervention is going to be medication. So having people take medication to treat an underlying mental illness or cognitive deficiency. 6 months of drug treatment sounds about right in terms of getting somebody to a state where the medication is going to be effective. It takes a long time for a lot of these psychotropic medications to actually take effect. So medication seems to be the most important factor in terms of restoring competence. So what happens if the treatment fails? Well, the Jackson ruling, the Supreme Court ruled that you cannot hold somebody indefinitely. So if treatment fails and you're not able to restore competency or competence in a defendant, you're gonna have to let them go in one way or another, right? So a lot of states will permit the defendant to be hospitalized for a period up to what the maximum sentence would be if they had been found guilty. That's kind of tricky, right? Because the person was found not competent to stand trial, so they did not have due process, so to speak, right? I mean, you could argue that they didn't have due process. They were not technically found guilty of anything, but a judge is mandating that they spend could be their entire life in a mental hospital, right? For a crime they technically didn't commit because they were never tried and convicted for. So it's a little iffy there, but we do know the Supreme Court says you can't just keep people in limbo. You got to do something with them. When it comes to whether you have the right to refuse psychotropic treatment, now this issue brings up, or this issue touches upon a number of rights that we have, constitutional rights, particularly. I mean, you can make a Fourth Amendment case about this, the unlawful search and seizures. These are our bodies. Can the government force us to take medication? Can they literally force pills down our throats? Do they have the right to do that? Yes, under certain circumstances, they do. So the government may forcibly administer psychotropic medication if the treatment is medically appropriate. So they can't just give you, stuff for the hell of it. it has to be medically appropriate. Also, it has to substantially unlikely to have side effects that can undermine the trial's fairness. So, one of the issues that we run into with psychotropic drugs are side effects, particularly if we're talking about antipsychotic medications. Some of those can produce pretty severe side effects when it comes to sleepiness, even, or when it comes to people's ability to control their behavior in the courtroom. The medications might affect a defendant's ability to pay attention or to even stay awake in the court. So those are negative side effects that a jury certainly could look down upon, right? So we have to make sure that any side effects would not be unnecessarily prejudicial to the defendant. And also, if the treatment is necessary to significantly further important government trial-related interests. What does that mean? Well, if the treatment is necessary to get that conviction, is essentially what that says, right? So the government can forcibly administer medications, if psychotropic medications, if it's medically appropriate, if it won't prejudice the jury, the side effects won't prejudice the jury, and if it's within the government's interest to do it, essentially is what it boils down to. So some other issues where competency can come into play. So the competence to waive Miranda rights. So we already discussed Miranda rights, and we've all heard them on TV and in the movies. You have the right to remain silent. Anything you say can and will be used against you in a court of law. Yada yada yada. We know the spiel there. But a lot of people end up waiving their Miranda rights and end up speaking to the police. They end up speaking to detectives, and that leads to hours of interrogations where some people end up confessing to things that they never did, right? So we've already touched on this when we went through the topic of confessions and interrogation techniques. So when we talk about the competence to waive Miranda rights, we're talking about that the waiver of these rights must be done knowingly, intelligently, and in a voluntary fashion. So the same guidelines that the Supreme Court has ruled when it comes to waiving your right to a trial by pleading guilty. So when somebody waives their rights, they have to know that they're waiving their rights. So it must be done knowingly. They must be done intelligently, which means, to me at least, and to many defendants and other legal psychologists, is that people who are waiving their Miranda rights should understand the implications of doing so. What are the potential consequences of waiving your Miranda rights? I'm not sure that's often the case among people who waive their Miranda rights, and we'll see in a minute. The majority of juveniles, minors, upwards of 80%, will actually waive their Miranda rights. We're talking about people who are underage, who can't enter into any type of legal contract under law, but they're able to waive their constitutional rights I don't know. That sounds shady to me. And of course, this must be done again in a voluntary fashion. We know that some coercive techniques can be used, and we know that investigators and police are allowed to lie to suspects, and all of those things can be used to try to get somebody to waive their rights. And the question is it really voluntary, or was somebody coerced into doing it? So defendants have a constitutional right to waive counsel. They have the right to represent themselves at trial, so you can waive the right to an attorney and represent yourself. That's not a good idea. Definitely not. And it's such a bad idea that if you do decide to do it, a judge will no doubt have questions about your competency. And, he or she might be satisfied with your answers and let you defend yourself, or they might send you for an evaluation. So essentially, the judge must be convinced that the waiver of your right to counsel is both voluntary and intelligent, that you actually know what the hell you're doing by making that really bad decision to represent yourself. Competence to refuse the insanity defense. This is an interesting one, and I had just seen a case on this. It was a pretty obscure case. I was watching Forensic Files or one of those shows there, where the defendant was clearly insane, and the defendant's lawyers wanted to enter a plea of not guilty by reason of insanity, which I'm sure would definitely have gone through. And the defendant was so pissed, and he said, "I am not insane. I knew exactly what I was doing. I want to fire my lawyers," right? So he fired his lawyers because they wanted to enter a plea of not guilty by reason of insanity. He wanted to deny this plea, to refuse this plea, refuse this defense, and say, "I'm not insane, and I'm going to stand trial," right? And there's actually a Supreme Court ruling on this here. You see that it's pretty old, 1979, which makes it 1 year younger than me in there. But Frendeck v. the U.S. In this case, if the court ruled that if the defendant understands the alternative pleas and the consequences of those alternative pleas, the defendant should be allowed to reject an insanity plea. Again, it's our right to do it, so long as we're competent to do it, alright? So long as we understand what it means if we reject this plea, and that we understand that kind of means that we're probably going to be found guilty and spend the rest of our lives in prison, or if you're in a state with the death penalty, that you might be killed, you might be put to death by the state. And this, talking about death penalty, brings us to sentencing. So competence to be sentenced. So defendants, in order for somebody to be sentenced, they have to understand why they're being punished. Excuse me. So they have to understand why they're being punished, why they're having their rights taken away from them, or in some cases, their life taken away from them. And they have to be able to meaningfully address the court, because the defendant has a right to address the court during sentencing. essentially, I mean, we'll get to how sentencing works when we get to the lecture on trial proceedings. But essentially, it's to ask for leniency, or to ask the judge to please take into account, how sorry I am and how much I've changed, and, how horrible of a life I had. Please take all that stuff into account before sentencing me. So basically asking the court for mercy. So you have a right to do that. And you also have the right to understand why you're being punished, or why the state is going to kill you. So we have to make sure that you understand those things. So issues of competency could come up during sentencing. And you might say, well, if they were found competent to stand trial, why would this issue of competency come up during sentencing? Well, because trials can last a long time. And sometimes between the beginning of a trial and sentencing, that could be a really long time, right? Like the O.J. Simpson trial lasted over a year. So a lot of stuff can happen in between that time. What if the defendant has a stroke in the middle of a trial, or before their sentence, after they're found guilty, but before their sentence, causes an issue that we need to evaluate. And again, when it comes to punishment, the ultimate punishment, execution. So the court has ruled that defendants can't be executed while they're incompetent. So you would a defendant who was deemed incompetent, before they could be executed, you would have to restore their competence. So that be done by waiting, or again, typically through treatment, or you can't execute them. So if you can't restore competency, it basically just turns into a life sentence, instead of a death sentence. Okay, so when it comes to the insanity defense, this is something quite different than competency. So the insanity defense is, I might have technically done the thing I'm being accused of, but I'm not guilty because I was insane at the time of the crime. So when it comes to competency, we're talking about the mental status or mental health state of the person during trial, or say after the crime, once they've been in the criminal justice process or system. Insanity deals with the mental health and state of mind of the person at the time of the crime. So we can kind of think of those two, insanity and competency, in that way. One deals with what the person was going through, or what their state of mind at the time of the crime. And competency deals with their state of mind at trial. So when it comes to the insanity defense, it requires one to gauge a defendant's mental state, again, at the time of the offense. And as I said before, insanity is a legal concept. It's not a psychological concept. So nobody's going to be diagnosed as insane. But a court can certainly find you insane. But to be a criminal offense, in order for any act to be a criminal offense, it must be, number one, illegal, right? So it must be written somewhere that you can't do this. It's against the law to do it. And it must be accompanied by the necessary mens rea, or what is called the guilty mind, which means that there has to be an intentionality behind it. If you accidentally kill someone, well, killing somebody is against the law. It's definitely illegal. But if it were accidental, you didn't mean to do it. Are you guilty of murder? Probably not, right? You might be guilty of negligent homicide or something if you didn't intend to kill the person, but you were negligent in some other way that led to their death, or involuntary manslaughter or something else. But pure accident type of situations where you were responsible otherwise, it just led to a horrible mistake or something. You were missing the intent part. We're missing the guilty mind part. So insanity deals with that aspect, the guilty mind, and we'll see, how that's defined or how to evaluate that when we take a look at some of the different kinds of insanity rules that exist. The McNaughton rule was a early attempt to define insanity. It's actually still used, or like a very close version of this rule is still used in the federal system and in 29 states. So it was an early attempt to define insanity, and it's still around. So it, quote unquote, excuses criminal conduct if the defendant, as a result of a quote unquote disease of the mind, one, did not know what he was doing. For example, believed that he was shooting an animal rather than a human. So they didn't know what they were doing at the time. Or two, did not know that what he was doing, and of course the law is written, it's an early law, he, she, they didn't know what they were doing was wrong. For example, they believed killing unarmed strangers was the right thing to do. There's a number of cases where people have clear mental illnesses, and again, mental illness in and of itself does not mean that you don't know right from wrong. But people who would kill their children as a way to, say, protect them, that they believed that by killing their children they were ensuring that they went to heaven or something like that. In a case like this, the person knew what they were doing was illegal, I'm sure, right? They would still know that it's wrong to kill, or not wrong, that it's illegal to kill, but that they were actually doing the right thing. That what they were doing was saving their kids by drowning them, let's say, rather than that they were intending to do harm, that they wanted to kill them, and they knew that this was wrong to do. They thought the opposite. So when it comes to the McNaughton rule, it's kind of a black and white type of decision. Is that you either knew what you were doing was wrong or not. There's really no in between. There's no shades of gray in there. And of course, when it comes to everything related to psychology, people's state of minds, there's really nothing that's black and white. There's always shades of gray. But the McNaughton rule is pretty definitive. It's like you either knew right from wrong or you didn't. That's it, right? So it doesn't really take into account that So maybe you were somewhere in between, or it's very categorical, not necessarily on a spectrum, in terms of determining whether someone knew what they were doing were right or wrong. The Bronner rule is a little different. It allows for some of that gray area to come into play while making this determination of insanity. So the Bronner rule stems from the model penal code, and this rule states that a defendant is not responsible for criminal conduct if he, at the time of such conduct, as a result of mental disease or defect, lacks substantial capacity either to appreciate the criminality, the wrongness, of his conduct, or to conform his conduct to the requirements of the law. So what does that mean? Well, we have conform his conduct. I put that in bold there, because we're basically talking about whether the person was able to control themselves, right? So we're starting to add shades of gray in there. The person might have known what they were doing was wrong, but they couldn't help themselves. So we're starting to measure insanity on a continuum. There's some gray areas in there. An example of this might be, say, temporary insanity. And the classic example is, you walk in on your husband or your wife of 20 years. You walk in on them cheating with your brother or your sister or both, right? And you just temporarily lose your mind and shoot them both to death, right? Be considered a crime of passion. So yeah, you knew it was wrong to do, but you couldn't control yourself, and this is often used as a defense. This is temporary insanity, crimes of passion, right? And sometimes they work. Usually, we'll see. Well, we'll talk about the effectiveness of insanity pleas in a moment here. They're usually, hint, they're usually not that effective. So the Bronner rule is now used in 18 states, and a version of it is used in the federal courts for some cases as well. Okay, so in which ways does the Bronner rule differ from the McNaughton rule? Well, basically in three major ways, and we kind of touched on them a little bit, but just to clarify, the first is by using the term appreciate. The Bronner rule, or the Bronner test, incorporates the emotional as well as the cognitive determinants of the criminal action. So it allows us to take into consideration what the person was feeling emotionally at the time of the crime. So again, think crime of passion. What was going through your head at that moment, right? Also, number two, it does not require that the offender exhibit a total lack of appreciation for the nature of their conduct, but only a substantial capacity. So they don't have to totally know that what they were doing was, say, good, or right. They could know that, or part of them could have known that, yeah, it is wrong for me to be shooting these people. But I just can't help myself right now. So the Bronner rule allows for a little bit of leeway. Again, little more shades of gray. So number three, it includes both a cognitive element and a volitional element. making defendants' inability to control their actions sufficient criteria by itself for insanity. Except you can't say, well, I was drunk, or, high or stoned out of my mind or something. That would not be sufficient. It would have to be of a mental issue or deficit at the time that made the person unable to control their behaviors, and that could be good enough according to the broader rule for an insanity plea. When it comes to, say, how the insanity defense is perceived, a lot of people get up in arms about it because they think it's a way for guilty people to kind of get off free and not be held accountable. We'll see in a minute that's typically not the case, but because of public outcry, and particularly in the 1970s, 80s, and 90s, even up to this day, we still very much have like a law and order type of approach to our criminal justice system. This is an issue that we discussed before. We're typically more interested in punishment and retribution than, say, rehabilitation. So there have been a number of attempts to try to reform the insanity defense, and because of those attempts, or at least in part because of those attempts, there's actually been considerable research that has looked into the issues surrounding the insanity defense. So the Insanity Defense Reform Act was in 1994. One prohibited experts from giving ultimate opinions about insanity. So what does that mean? Well, it prevents a psychologist or a psychiatrist or medical doctor or a social worker. It prevents them from going on the stand and saying, it is my opinion that this person was insane at the time, or that they did not know right from wrong at the time that they committed this crime. So an expert cannot give ultimate opinion testimony when it comes to insanity, to the issue of insanity. Number two, the burden is now on the defendant to prove insanity. So it's now an affirmative plea. Before this reform, the burden was on the prosecution to prove that the defendant was sane. So this is probably, well, depending on how you view the insanity defense, this is probably a good thing, right? That now it's an affirmative defense. So even with the changes put forth by this Reform Act, research suggests that verdicts do not significantly differ as a function of whether jurors have heard jury instructions that inform them about the Insanity Defense Reform Act, whether they have heard Bronner instructions or no instructions at all. So it doesn't really seem to make a difference whether jurors know the actual legal criteria that's outlined in these different tests or in these different protocols to determine insanity. It doesn't really seem to make a difference in terms of the verdicts that they end up reaching. So just a couple of facts about the insanity defense, because it is a very misunderstood defense. Again, there's this common perception that people are using it all the time and getting away with murder, literally and figuratively. But the insanity defense is most often used in cases in which the defendant is charged with a violent felony. No surprise there, right? Also, the majority of defendants found not guilty by reason of insanity have been diagnosed as psychotic, as suffering from psychoses, which means they don't know what's up, right? They cannot distinguish reality from delusions. So the majority of people found not guilty by reason of insanity legitimately can't tell the difference between what's real and what's not. In one study here, we see it's a little old, 86, but again, this was the time when there was a lot of concern about the insanity defense, so it was timely at the time. But Rogers estimated that about 1 of 4 or 5 defendants, so we're talking about 20-25% of defendants being assessed for insanity, engages in at least moderate malingering of mental disorders, which means that even though we'll see that most people who are assessed for insanity turn out not to be insane, still a good proportion of them have some serious mental disorders that are going on that could have or likely did contribute to their commission of this act. Usually it's a violent act, right? So we'll see that there is a little in some cases there's a plea that allows jurors to take that fact that they might not be insane, but they still have some issues that contributed to this crime, that some jurisdictions allow jurors to take that into consideration when reaching a verdict. But when it comes to public perceptions, as I said, there's a lot of misconceptions among the public. 3 prevalent beliefs among the public is that a large number of criminal defendants use the insanity defense. That's not true. Another misconception is that those defendants found not guilty by reason of insanity are then released back into society. Once they're acquitted, they're found not guilty, we're going to have a bunch of crazy or insane murderers roaming the streets. That is not true at all. And number 3, that people found insane are extremely dangerous. And that is definitely not true in the majority of cases. We see here that the insanity plea is used only about 0.9% of the time. So that's 9 out of 1,000 pleas raised in criminal felony cases. And of those, only about 2 will be successful. So the insanity plea is extremely rare. We're talking about less than a 10th of 1%. It's a very rare plea, and it, even when it does go through, when it is allowed, only 2 of these 9 of 1,000 cases will be successful. So very rare, and in the majority of cases, they're still found guilty, right? So really not something that we need to be overly concerned about here. I spoke a little bit how there have been some revisions that have been made, that jurors are allowed to take into consideration mental illness without deeming someone to be, quote unquote insane. So some states, about a fourth of states, allow jurors to reach a verdict of guilty but mentally ill. So what is this? Well, if a defendant is found guilty but mentally ill, a judge will typically sentence that defendant the same way as one who is found guilty of the same offense. So they're not getting any type of special treatment or going to a mental hospital. Someone found not guilty by reason of insanity, they're not going back on the streets. They're going to a hospital. They're going to be spending a lot of time in treatment. When it comes to guilty but mentally ill verdicts, research shows that they're kind of sentenced just like any other person who was just found guilty. In some jurisdictions, though, the defendant who is guilty but mentally ill would start his or her term in a hospital or in a treatment facility, and then they would be transferred to prison after their treatment is completed. So, in other words, the individual would receive mental health treatment while they're serving their prison sentence. The defense of diminished capacity. Okay, so several states allow a defense of diminished capacity, and it applies to defendants who lack the ability to commit a crime purposefully and knowingly. Diminished capacity is not the same as insanity, but we could think of, say, in terms of how these differ, is that diminished capacity is focused on whether defendants had the state of mind to act with purpose and intent to commit a crime, not on whether they knew that their behavior was right or wrong, or whether they could control their behavior. So this is related to the defense of guilty but mentally ill. It means that the person likely knew right from wrong, but they had diminished capacity to act with intent or act in an appropriate way. They had a diminished. It's hard to explain. It's not often used. Again, only several states allow for this, and when it comes to these types of verdicts or revisions of the insanity defense, again, it's saying, yeah, the person is guilty, but we're going to take into account that, they might not have been in the right state of mind when they did this thing. Judges typically, again, will sentence the person to the same sentence that someone who's just found guilty was sentenced to. We also see the elimination of the insanity defense in 5 states. So 5 states have totally abolished it. You don't get to use it at all. That's pretty severe, I would say. Totally not allowing for much discretion there. When it comes to capital sentencing evaluations, so the Supreme Court fairly recently ruled that minors cannot be executed, and people with severe mental or developmental disabilities cannot be executed. But we also saw that when it comes to competency, defendants have to be deemed competent in order to be executed. When it comes to capital punishment executions in general, the Supreme Court ruling, again, Eddings v. Oklahoma, held that a trial court must consider any potential mitigating information. So mitigating information is evidence that argues against a death sentence when considering a sentence of death. So if a judge is considering the death penalty, the judge must consider mitigating information. So mitigating information might be that this person suffered some really horrible trauma in their life, that they suffer from mental illness or drug addiction or whatever the case may be, that they saved a whole bunch of puppies from a burning building once, right? Anything that kind of argues why you shouldn't put this person to death. So the Supreme Court ruled that any time that the issue of capital punishment or a capital sentence comes up, a judge must consider these types of mitigating circumstances. So in order to do so, there's usually a clinical evaluation that's done. So a clinical evaluation in this nature must also address the question of eligibility for capital sentencing if the defendant is intellectually disabled, right? So people with intellectual disabilities cannot be executed. That's a fairly recent ruling by the Supreme Court. When it comes to this issue of neuroimaging, you already know, if you've been watching my these lectures, you already kind of know my opinion on neuroimaging in the courtrooms. Not a fan, but neuroimaging is, or this type of neuroimaging based evidence has started to find its way into the courtroom to help resolve a whole bunch of issues. We saw it's finding its way in to kind of be used as a lie detector, which is completely unacceptable to me at this point. But it's also being used to help resolve issues related to competency. That might be more appropriate if you're able to show that part of a person's brain is no longer functioning due to trauma, such as stroke or something of that nature, or advanced Alzheimer's or dementia. So issues relating to competence or the capacity to form a mental state necessary to be guilty of a crime, that's an interesting area where neuroimaging might be useful. Is that this type of evidence can be used to show that a person lacks the parts of the brain that are necessary to actually plan a crime, right? So if we're talking about a crime that took extensive planning and a lot of quote-unquote executive action happening in the brain, well, we could see from this brain scan that this person lacks the ability to do that. The brain's not there. It's deteriorating, or it's damaged, or it's dead from lack of oxygen or blood flow, right? Also to resolve issues of criminal responsibility. So again, insanity, as mitigating evidence in capital hearings, particularly during the penalty phase, to determine whether or not somebody should receive the death penalty. When it comes to this type of evidence, we have to ask ourselves or be mindful that jurors are just human beings that come from all different backgrounds. They're not scientists. They're not psychologists. They're not trained in any of this type of new science. This is regular people, lawyers and judges, even neuroscientists themselves might not really appreciate that there's more to a brain image than the work of a scanner. I mean, this always is what kind of drives me nuts. Sometimes when we talk about, well, this part of the brain doesn't work, so, and that part of the brain is responsible for this, and, well, no, that's not really how the brain works. I mean, there's some parts of the brain that are more responsible for certain things than others, but kind of the whole brain works as a team up there. So what I'm getting at is that the people who are evaluating this type of neuroimaging evidence might not be the best people to evaluate this neuroimaging evidence. They might not fully understand the limitations of such evidence and the implications of such evidence as well. So we also see that results from such studies have potentially severe limits on the ability to generalize results to real world tasks. So a lot of these brain imaging studies that we're seeing, like, this person lacks or has diminished capacity in this part of the brain responsible for decision making. Yeah, but they were inside an fMRI machine for God knows how long, and fMRI machines are incredibly claustrophobic, and there's loud pounding magnet slamming in there, making all this horrible noise, and you have to make a really mundane and not realistic type of real world decision. You have to choose between left or right or something like that. I mean, are those results generalizable to actual decisions that you have to make on a day-to-day basis out in the real world outside of an fMRI machine? I don't know, right? Particularly because these studies tend to have pretty small sample sizes, and it's because it costs a lot of money to run an fMRI and to maintain an fMRI. We also have to remember that these images that we see in articles and on posters or that are presented in courtrooms about this is the brain image of somebody with psychosis, and this is the brain image of a quote-unquote normal person. We're not looking at individual brain images. We're looking at composites. Those might be the average picture of 10 different images of a person together. So you kind of need some expertise to interpret those results. A lot of people think that they're looking at individual brains, but they're not. They're actually averages of people. So not everyone with psychosis is going to have a brain that looks like that. That's the pooled image. So who's equipped to really evaluate that? I know I'm not, and I have a fucking PhD in psychology. So I don't know, is a lawyer or a judge able to do it? Not so sure, right? When it comes to this idea of, again, using fMRIs or other neuroimaging techniques to kind of read a person's mind, there's really no valid current or foreseeable uses of fMRI as letting us, read somebody's mind. It's really just kind of not how the brain works. And the idea that behavior has a biological basis does not mean that doesn't mean that behavior is necessarily biologically determined, right? So yeah, some behaviors might be rooted in biology, but they're not caused because of some biological event or predisposition or characteristic, right? We know that biology has to interact with the environment to produce outcomes. There's no like psychopathic gene, even if psychopathy is genetic, which there's some evidence to suggest that it might be. In order to produce a killer, like you need some traumatic life experience to happen pretty early in life, even. So, just because some behaviors might have a biological basis, we still have to consider what environmental influences or interactions were involved to cause that outcome. Also, brain patterns change over time and in different circumstances. So our brains change, and brain patterns can change throughout the day. Different parts of the brain are more active than others, and yeah, sometimes that depends on the situation that we're in. I'm gonna assume being inside of a fMRI for an extended period of time is likely to have an effect on brain patterns, just by being in that machine, I would say. So there's some concerns that jurors basically seeing this type of evidence, literally seeing these scans of, say, a malfunctioning brain, might be unduly persuaded by this type of testimony. Just like we know that eyewitness testimony is incredibly damning, and confessions are incredibly damning, because jurors put a lot of weight and a lot of trust into confessions and to eyewitness testimony. They tend to also be really impressed with this type of science, overly science jargon type of descriptions and images. We'll talk more about that once we get to the topic of expert testimony. But long story short, the neuroimaging is really way too early to be making its way into the court, but it is, and jurors tend to value this and trust this type of evidence disproportionately to more trusted and established forms of evidence. So it could be problematic. Let's forget about that. Keep talking about neuroimaging here. One other defense that can be raised is the issue of battered women syndrome. It's not necessarily a defense in and of itself. Usually the defense would be not guilty by reason of self-defense, or not guilty by reason of insanity, whatever it might be. But the case is rooted, or the plea rather, is rooted in the notion of battered women syndrome. And battered women syndrome was introduced in the 70s by Lenore Walker. It was part of the overall movement of the 70s, the second wave feminist movement, and also the civil rights movement. And even in the 70s we had a pretty active LGBT movement as well. So 1975, Lenore Walker was the first psychologist to study battered women and the problems that battered women often encounter. And when we think about the battered women syndrome, we should think of it as a psychosocial construct that combines psychological stresses caused by deliberate and repeated abuse, typically at the hands of an intimate partner. So Walker hypothesized a 3-stage repetitive cycle of violence that would occur in these types of battering relationships. And the first stage is this tension building stage, and it consists of a buildup of minor, quote unquote, minor type of abusive incidents, in which the woman attempts to placate the batterer, try to calm him down, try to get things back to normal, so to speak. Then there's an acute battering stage in which the severity of the abuse increases, and the woman is subjected to a very violent battering incident. The third stage is the contrition stage, and this involves a period of relative calm, where the abuser will tend to show a lot of remorse and promise never to do it again, and they might buy their victim gifts and try to keep the relationship going, or try to keep this person to stay with them and not leave them. The problem, of course, is that this is a repetitive cycle. So after the contrition stage, it just starts over again with stage 1, and the cycle repeats and repeats. So we see that in 1983, Walker revised her theory, or her cycle there, in utilizing Siegelman's theory of learned helplessness to try to explain the woman's sense of quote-unquote psychological paralysis. So Walker used the theory of learned helplessness to try to explain why a lot of women will actually stay in very abusive types of relationships. So essentially, women will begin to live in a state of constant fear, perceiving that there's no escape from the situation, especially if the abuser is making active threats to harm her, or to kill her, or to harm her or kill her family or friends. There's an increase in isolation, so the battered woman would become increasingly isolated from friends, families, colleagues. Increased feelings of guilt. The battered woman would be, increasingly blame herself for the situation that she's in, and an increase in fear of trying to escape the abusive situation. So they start to believe that that maybe killing their abuser is really the only way out of this type of abusive situation. So they reach, according to Walker, right, reach a level or a point where there's really no other option but to kill their abuser. So we'll see why this is a problem in a minute here. So here it is. Well, a little taste of some of the problems. The obstacles to this type of self-defense claim stems primarily from two sources. The one are the laws on self-defense and insanity, and two, the presumed beliefs that people harbor about the consequences and effects of male violence against women in intimate relationships. That's a lot of words to just say that one of the obstacles to the battered women's defense is that people tend to not take abuse in intimate partner relationships all that seriously. So the other obstacle, of course, is that there are particular laws that outline what constitutes self-defense and insanity, and battered women syndrome does not fit neatly within these criteria. most of the time. So in order to make a claim of self-defense, or a successful claim of self-defense, a defendant must fulfill four elements of the defense, or the self-defense claim, right? So in order to be successful in a claim of self-defense, the defender must have believed that she was in imminent danger of unlawful bodily harm at the time of the act. 2, the defendant must have used a reasonable amount of force to respond to the threatened danger. 3, she cannot have been the aggressor, so she could not have been the one who started the fight, even if it ended up where she had to kill him in self-defense. So that's something to keep in mind. You can't kill someone in self-defense if you're the one who started the altercation. And 4, in some jurisdictions, the defendant must have had no opportunity to retreat safely. So in many states, in order for you to claim self-defense, you first had to try to escape the situation without using any force. So let's just take a look at these 4 elements one more time in normal people language here. So first criteria is that you have to believe that you're in imminent danger of severe bodily harm or death at the time that, say, you killed this person in self-defense. Number 2, you had to have used a reasonable amount of force to respond to that threat of danger. So you can't shoot someone, 20 times and claim self-defense. That seems like excessive force, not reasonable force. Like we said before, you couldn't have started the incident. You couldn't have been the aggressor, the person who started the incident that led to killing the person in self-defense. And in a lot of the jurisdictions, you have a duty to retreat, meaning that in order for the self-defense claim to work or to be valid, you first had to show that you had no opportunity to retreat, to get out of that situation without using deadly force. When it comes to the self-defense claim or plea, it could get tricky. This is from a Canadian Supreme Court justice, but it applies to the mentality that kind of exists within our legal system here. It's quote, and it reads, "If there is a significant time interval between the original unlawful assault and the accused's response, one tends to suspect that the accused was motivated revenge rather than self-defense." Right? So this type of mentality can cause some problems when it comes to the battered women's defense, because a lot of times if women who are the victims of battering believe that killing their abuser is the only way for them to escape their situation, they're likely to kill their abuser at a time where he's going to pose the least amount of danger, when he's asleep or he's intoxicated or incapacitated in some way, right? So the law does not require the defendant to attempt to escape from the abuser or to leave the relationship earlier. However, the woman's failure to do so might still influence the way that the jury thinks, right? A lot of people just think, how many times have we heard, or we might have even thought ourselves, like, why doesn't the person just leave, right? That's pretty common. particularly for people who haven't experienced or witnessed abuse firsthand. It's not unreasonable for people who don't know better to question that. So even though the law doesn't require a woman to have tried to leave her relationship, her abuser, it's still likely to influence the way that the jury is evaluating the evidence and likely their verdict, right? So what are some of the effects of the battered women syndrome defense on verdict? Walker stated that at best, battered women's syndrome testimony will reduce a verdict of murder to manslaughter. That's been from my personal experience in teaching this class even. One of the reasons why I include battered women syndrome in this part of the lecture in this topic is that for a number of years I used a case for mock trial that used battered women's syndrome as a defense. Essentially, the case was about a woman who killed her husband and was claiming battered women syndrome, or not guilty by reason of self-defense. And over the years, from various things that I've done to kind of spice things up, that's kind of been my experience as well. Is that no one ever really found her not guilty, but very few jurors or juries would find her guilty of murder one, premeditated murder. Most people would find, or most jurors returned a verdict of manslaughter. So, yeah, Walker was kind of spot on, at least in terms of when I replicate this stuff in my classes, right? And Walker in 1990, more recently, 90, still long ago, but remember this was first developed in 75, indicated that in over 25% of these cases, the women were fully acquitted. So it seems like more recent research. Again, I would still like to see what the data suggests now, or if we could get some more recent research here. But it seems that battered women syndrome is becoming, let's say, more believable to jurors. So we see in about a quarter of the cases, according to this data, which is still kind of old, the battered women syndrome defense was successful. In another study and a review of the 26 cases in which battered women syndrome testimony was permitted, 33% of women were acquitted, and in the cases where it was excluded, all of the women were convicted. So this is, again, pretty old research here, so definitely areas that can use some updating, some research areas that can use some more modern studies, more modern results here. So it looks like battered women syndrome testimony can be effective. It's not leading to 100% acquittal rate, not even 50-50. In Walker's case, she's reporting a quarter of the cases. In this other study, a review of just 26 cases. Remember, this defense is not really that common. It's kind of a rare defense, but at least among those 26 cases that were studied, we saw about a third of the women were acquitted, and in the cases where it wasn't brought up, they were all convicted. So seems like there's some promise to the defense. There are a number of limitations to battered women syndrome. Number one is that it's not really recognized as a psychological syndrome or psychological illness, right? It's not included in the DSM. When people study, it depends who is studying battered women syndrome, but some more of the feminist oriented psychologists, feminist psychologists will try to they will often try to present battered women syndrome as something separate and something unique and something that should be included in the DSM. But other researchers who study battered women syndrome will say that we're really just talking about PTSD, post-traumatic stress disorder. So Walker found that only 65% of the cases involved the attention building stage prior to the battering, and in only 58% of cases did a period of loving contrition follow the battering incident. So Walker created these models, or created these stages, these 3 stages, and her own research shows that they're not universal, right? Only 65% of cases had a tension building stage, and only 58 had a contrition stage. But she says that her model has these 3 stages. Well, that's a lot of cases that don't fit your stages there, that don't fit your own model, right? So that's a limitation. Also, Walker concluded that the loving contrition stage was absent in some relationships, but that it just disappeared over time in others. So in other words, that contrition, that please take me back, I'll never do it again, might just go away over time, and it just becomes a 2-stage model at that point. I have a lot to, add and to say about intimate partner violence because I studied for my dissertation, how I got my PhD. I studied the effects of sexism and homophobia on straight people and gay, lesbian, bisexual people's perceptions of same-sex and opposite-sex intimate partner violence, essentially. So I studied how people perceive domestic violence or intimate partner violence in gay and lesbian and straight relationships, and tried to see what role sexism and homophobia might play in them, in their decisions and their perceptions. And generally speaking, people saw same-sex domestic violence or same-sex intimate partner violence as being less serious. But it wasn't just straight people. Gay, lesbian, and bisexual participants also rated same-sex violence as less serious. And sexism and homophobia didn't fully explain it. So I have another idea of what it could be that's going on. But I never did that follow-up study. So anyone interested in doing some research, maybe we can follow up on that one day. Also, when it comes to some limitations of battered women syndrome, the applicability of learned helplessness has been questioned. When women in battering relationships were compared with a sample of battered women who just ended the relationship, there was little support for Walker's idea of learned helplessness when it came to the data. that came from researching these types of relationships. Also, the majority of battered women engage in a variety of responses in attempt to end their abuse. So, leaving the relationship is just one way of trying to end an abusive relationship. There are a number of different ways that we're focusing on women here, but of course men can be victims of battering as well. This most of the research is focused on women victims of battering, and battered women syndrome has been used in the courts. We haven't really seen men, or not too many cases, very rare for men to use this type of defense. So that's the only reason why I'm focusing more on women and not men as victims. But men absolutely can be victims as well. And that's the end. Okay, so my voice is shot. I'm gonna just say goodbye, and I'll see you next time. Enjoy the weekend. Take care, everyone.